Clerk, open the roll for attendance.
You are.
And the clerk will close the roll. A quorum is present. So good morning and welcome to the Constitutional Amendment Subcommittee of Privileges and Elections. I just want to make an announcement for folks that are watching that we have, the Subcommittee on Redistricting, not the Redistricting Subcommittee, but the Subcommittee on Redistricting. So a couple quick administrative announcements and then we'll dive right into this docket because we have a lot of stuff that we need to do. And we have two deadlines. We have a soft deadline of 11. We all have to be in caucus by 11, so my goal would be hopefully to get done by then. We have a very, very hard deadline, though, not long after that, when the gavel hits in the floor at 12 noon. That's not a deadline that we can move. But I expect we'll be able to get through this hopefully in about an hour. So I think we have all the bill patrons here that have bills on the docket. And so Delegate Van Valkenburg, if I could get your attention for just a second, and Delegate Levine, Delegate Cole, Delegate Price. Do any of you all have amendments or substitutes to your bill? If you could let me, what I'd like to do for the sake of transparency is in a block move to adopt any substitutes and amendments to any of these bills so that we can get copies put on the front table for people in the audience that want to see what the substitutes look like, and also get these released online for those of you that are following along online, rather than having the substitutes come up one at a time. So Delegate Van Valkenburg, are you okay? Do you have a substitute to any of your bills? Which bill numbers is that? 758? Okay, Delegate Levine, do you have?
1054.
And Delegate Levine has substitutes to 754. Delegate Cole, do you have any amendments or substitutes? Delegate Price, do you have any amendments or substitutes?
Yes, to 1255 and 1256.
All right, so I would entertain a motion to adopt the amendments and substitutes in a block so that they'll be properly before the committee so that they can be released on IHOD and released to members of the public that are here. Is there a motion like that?
So moved. Second.
It's been moved and properly seconded that we adopt all the amendments and substitutes in a block so that they can be released to the public. As many as favor that motion will say aye.
Aye.
Those opposed, the motion carries. All right, so the amendments and substitutes will be before us as we go through the docket and call the bills up. All right, so I'm going to go ahead and start with Delegate Cole. Delegate Cole, you want to present from your seat or you want to take the podium?
Whatever you'd prefer.
I'm fine with you taking it from your seat.
Okay.
And so we've got House Joint Resolution 3 first, and then depending, I think, on what our pleasure is with that, we may have a ballot bill to follow up if depending on how that goes. We may not need to do that one. So why don't you go ahead and present House Joint Resolution 3.
Okay, thank you, Mr. Chairman. House Joint Resolution 3 is a constitutional amendment to allow minor technical adjustments to districts to be made to try to reduce split precincts. Of course, it passed last year, and this is the second resolution. I think it's necessary in the light that we can no longer, this used to be standard practice after redistricting. We used to make minor technical adjustments after every redistricting to reduce split precincts and split communities and neighborhoods and things like that. And due to a court decision, I understand that's no longer permitted without a constitutional amendment. And again, this is just to try to get at the split precinct problem, which seems to be a chronic problem in elections.
Are there any questions for Delegate Cole from members of the subcommittee? Is there anyone do you have a question for Delegate Cole? Delegate Price, please use your request to speak button.
Thank you. Mr. Chairman, Delegate Cole, does this also come with an adjustment of the allowed percent deviation that we currently have at plus or minus 1%?
It requires, Mr. Chairman, if I may, it requires that any adjustments be consistent with the previously adopted deviation and also all the requirements that were placed on the initial redistricting. It would not allow deviation beyond what was originally adopted in the redistricting criteria.
Are there any other questions from members of the committee? Delegate Lindsay.
Mr. Chair, the question for Delegate Cole is, given this circumstance, would this in some way give us, the legislature, authority even over those decisions made by a redistricting commission?
Mr. Chairman, I would respond that it would allow us to make minor technical adjustments after a redistricting. The main problem, and it's been, I think, a problem across the state, is the handling of split precincts. And I don't care who draws the boundaries of the legislative districts, you're still going to end up with split precincts, because at the same time, whether we do it or the redistricting commission draws the legislative and congressional boundaries, localities are redrawing their own boundaries, including their precincts. And so that's how you end up with split precincts. And again, this would allow the General Assembly to make, and there are parameters put on it, make minor adjustments after the redistricting to try to reduce the number of split precincts.
Thank you, Delegate Cole. So it sounds like that, Delegate Lindsay, the answer was yes, they could do that. Delegate Orrock.
Yeah, Mr. Chairman, just briefly speaking to the matter and following up on Delegate Cole's comment.
Delegate Orrock, if you don't mind, let me take, if it's not a question for the patron, if I could go ahead and hear from the audience first. Is there any member of the audience wishing to speak in favor of House Joint Resolution 3? Anyone wishing to speak in opposition to House Joint Resolution 3? All right, Delegate Orrock.
Yeah, because the problem, and I've seen it every time we've been through redistricting, the fact that we draw our lines and have to, no matter who's drawing them, even the citizen commission that may exist would have to go by the existing precinct lines, and then local government comes through at a little bit later time in the year, and they establish new precinct lines. I think this only makes good sense. It doesn't negate what any citizen commission would have done. It just modifies it within the parameters established to make for less voter confusion, make it easier on the registrars, and I think increase the validity of the voting process. So I hope the committee will act favorably on the resolution.
All right, before I think we're about ready for a motion, I just briefly, Chairman's prerogative to respond to that. I think one of my big concerns about this is that, in fact, localities draw precincts. And I think that, as we go forward with redistricting, there's going to be some criteria that involves communities of interest and things like that. And sometimes those lines might be drawn, very specifically to keep a community of interest together. And I'd hate to see a locality then draw a precinct line right through that community for the purpose of undoing what was intended by the commission. So with that, the committee operates by motion. It's been moved and properly seconded to report. Is there a substitute motion?
Substitute motion.
Delegate Lindsay.
Move to table.
Delegate Lindsay moves to table.
Second.
It's been seconded. That's non-debatable. The clerk will open the roll.
Yeah, somebody is missing. Reed.
No, Reed's here.
When did Reed come? Oh.
The clerk will close the roll. And the motion to lay on the table is 5-3. So I think, Delegate Cole, your ballot bill probably needs the same motion. Is there a motion to lay House Bill 14 on the table?
Second.
It's been moved and properly seconded to lay House Bill 14 on the table. As many favor that will record their vote on the electronic voting board. And that bill's laid on the table by a vote of 5-3. All right. Delegate Helmer. Delegate Helmer. You've got a constitutional amendment second reference as well. Your House Joint Resolution 103.
And Mr. Chair, members of the committee, may I speak to House Bill 1268 as well, which accompanies it?
Delegate Helmer, that will maybe. It depends on what we do with House Joint Resolution 103. So I suspect yes, but I can't promise you anything yet.
Yes, Mr. Chair. Mr. Chair, members of the committee, House Joint Resolution 103 is a constitutional amendment that addresses a patchwork of laws that we have, or local ordinance related to providing an exemption for local taxing of veterans' vehicles, fully service-disabled veterans' vehicles. The purpose of this resolution is to amend the Virginia Constitution and to ensure that veterans with 100% service-connected disability receive an exemption for their primary vehicle, just like the exemption provided for real estate.
Are there any questions for the patron from members of the subcommittee? Is there anybody in the members of the audience wishing to speak in favor of this joint resolution? Please step forward.
Mr. Chairman, members of the committee, I'm Rick Ortel. I represent the Joint Leadership Council. This is one of our priorities for this year. We do support this measure.
Is there anyone in the audience wishing to speak in opposition to the amendment? Please identify yourself.
And for the amendment.
Oh, for. I'm sorry. So
I'm a veteran. My wife's 100% dis.
Okay. Anybody else who's for the amendment, get on up and get in line. And, sir, you may proceed.
My name is Philip Thompson. I am a veteran. My wife is a 100% disabled veteran, and we're fully in support of this amendment.
All right. Anyone wishing to speak in opposition to HJ 103? All right. The committee operates by motion. It's been moved and properly seconded to report House Joint Resolution 103. As many as favor of that motion will indicate on the electronic voting board. The clerk will open the roll. The members will cast their votes. The clerk will close the roll, and that motion is, so the resolution is recommended for reporting by a vote of 7-1. Delegate Helmer, that being the case, we now need to take up House Bill 1268, which is the ballot bill for your constitutional amendment.
Mr. Chair, members of the committee, House Bill 1268 is the ballot bill for the amendment that you that you just passed through, reported through committee. I'm happy to answer any questions addressing.
Are there any questions from members of the subcommittee? Is there anyone in the audience wishing to speak in favor of the bill? Anyone? You don't need to. Well, go ahead. I did ask.
Mr. Chairman, members of the committee, Rick Ortel again. We favor this bill. It's a JLC priority. Thank you.
All right.
Good morning, Mr. Chair. Carrie Ann Alford, Staff Administrator for the Joint Leadership Council, and I can let you know that on the Senate side, Senator Reid did put in a budget amendment to cover the ballot initiative. Thank you.
Thank you. Anyone wishing to speak in opposition to the bill? The committee operates by motion.
Somebody moving the report?
It's been moved and properly seconded to report House Bill 1268. As many as favor of that motion will indicate on the electronic voting board. And the bill is recommended for reporting by the subcommittee by a vote of 7-1. Thank you, Delegate Helmer.
Thank you, Mr. Chair, members of the committee.
Congratulations, Delegate.
All right. All right. I want to move on. I'm going to move now to our two criteria bill. That's the criteria block. And I think that we've got two criteria bill, one from Delegate Levine and one from Delegate Price. Delegate Price, do you want to present from here or from up front?
I can go there in case you have questions.
Yep. All right. And so what I'm going to do with these is I'm going to let both patrons present their bills, and then I'm going to hear from members of the audience. They're here to talk about criteria, and you can tell me that you like one or both, or which one you like better. You can tell me you're opposed to one or both, and which one you like least. And then we will entertain motions from the committee. So with that, I'm going to go ahead and let Delegate Price kick it off with House Bill 1255.
Okay, and Mr. Chairman, we are operating from the substitute already?
The substitute has already been adopted and is before us. It's available online on IHOD and LIS, and there are copies at the table in front for those who'd like to get them.
Thank you. Mr. Chairman and members of the committee, gerrymandering, as you know, has been undermining our democracy and a bit of transparency. I've been studying this and fighting for more fair districts since I learned of gerrymandering in high school and wrote my International Baccalaureate extended essay on the topic of how it negatively impacts black voters. So the act of drawing lines to disfavor or favor any group or drawing lines district lines to pack racial or language minorities purposefully into a district erodes trust in the political system, nurtures a sense of apathy versus participation, and can dilute political power in ways that have intergenerational effects. And other products of gerrymandering are less accountability, legislatures that don't represent the demographics of the Commonwealth, and an unequal weight of Virginians' votes. So a lot of the conversation that you've been hearing about redistricting reform has really heavily been placed on the who that does the drawing of the maps. And so HB 1255, I think more importantly, addresses the how and the substance and values of the ways in which maps can and cannot be drawn, no matter who is doing the drawing. So HB 1255 does a few things. It establishes criteria for how state legislative and congressional districts should be drawn. It includes a deviation of up to 5%, helping eliminate some of the confusing split precincts. It includes the actual language of Sections 2 and 5 of the Voting Rights Act that are applicable to the act of redistricting. It has protections for communities of interest. The districts must be contiguous and compact, and it would end prison gerrymandering. The rest of this, Mr. Chairman, the language should look, excuse me, sorry, and it has, did I take off that? Sorry, 1 second. Just want to make sure. Yes, and it also has the timeline for which the information needs to be reported from the correctional facilities. I believe that 1255 would promote more trust in our democratic system and inspire more participation versus less.
What I'm going to do now is to go ahead and let me go ahead and let's see if there's questions for Delegate Price. I'm sorry, Mike's not right. Let me go ahead and start with if there are questions from the committee for Delegate Price. Let's take those subcommittee questions first, then we'll have Delegate Levine present and take questions, and then we'll get questions from the audience, or comments from the audience. Delegate Bloxham.
Thank you, Mr. Chairman. Got a question on the bill on the substitute on line 87. I think I'm probably the most split district in the state. And I'm trying to figure out how, with this language, how it's going to affect my district, where I've got a piece of Norfolk, but yet I've got the Eastern Shore, and I'm trying to make sure that in the past, I think water was not considered a boundary. And I didn't know with this writing, it's more of a question. I don't know if council can help either on this.
So
The language is intended for the water to be taken into account, but not purposefully used to split a district. So it's Meg, is the running downstream or upriver part. Did you want to add anything?
No, that's correct. So if you were looking at your map and you remove the water, if those two sides would still be contiguous without the water there, then it's fine.
But if you have to get in a boat and float down to the rest of your district, then that's no good. Is that right?
That would be correct.
That'd be a connection downstream, yeah.
Delegate Cole.
Yeah, and again, I understand the intent of those lines, 87 and 88, but I'm not sure that's what it says. It seems to me, localities like Tangier Island, they're in the middle, of the water. But they're only connected by others by water.
Right. So, Mr. Chairman, and please, counsel, if I'm wrong, I think
Delegate
that
Price.
thank you, Mr. Chairman. I'm sorry. I think the point is, if you were to remove the water, it would be a contiguous territory.
Counsel, I think I don't share necessarily Delegate Cole's concern. I think that moving water is distinguished from the Chesapeake Bay, and the Chesapeake Bay itself is not a river that moves upstream or downstream. Would you agree with that? Maybe you don't have to. It's okay. Anyway, that's not really a legal question, so I'm going to go ahead and leave that where it is. Are there any other questions from members of the committee? All right. Delegate Levine, why don't you go ahead and present your bill, and then I'll take questions for you, and then we'll get input from any members of the public.
Thank you, Mr. Chairman, members of the subcommittee. My bill, the nature of the substitute 1054, has a lot of similarities to Delegate Price's bill. And in fact, I would support either my bill or hers. Obviously, I think mine's a little better. That's why I drafted it this way, but I certainly would support hers as well. In fact, 19 and 20 of my bill, I think, addresses the water question a little bit better, for example. And I think it describes a little bit better, and you might want to amend it to do that. The heart of the difference between, I should also note that while Delegate Price's bill mentions prison gerrymandering, I have a separate bill, HB 319, that deals with prison gerrymandering, which at some point I'd want to discuss. There's some slight differences between my prison gerrymandering and hers. But with regard to the criteria, I note that in 9293, paragraph 8 says something that I very much like in her bill. It says, a map of districts shall not, when considered on a statewide basis, unduly favor or disfavor any political party. The heart of my bill takes what is in those two lines and draws it out in a specific mathematical formula. Unduly favor or disfavor may be in the eye of the beholder, particularly when you throw the word unduly in there. What I've done is I've said basically design the districts pretty much with the same criteria that Delegate Price has. You'll find all the same thing: communities of interest, respecting the Voting Rights Act, no harm to racial minorities, contiguous territory. The language is pretty much the same, except that what I say is that when you're done looking, you compare it to a hypothetical map based on past elections to determine the average expected partisan vote per precinct. This is a formula I developed with some of the best gerrymandering political scientists across the country, helped me develop this formula. I'd be happy to answer questions about it. It actually looks at the Lieutenant Governor and Attorney General of Virginia races specifically because those are the ones where we think it's more likely that people voted based on party than based on a preference, like for the President or the Governor, where they probably know voters are clear who they're voting for. Sometimes on the down ballot races, they just vote based on party. But basically, it says, do what Delegate Price's bill does, and then check it against this criterion of fairness to see whether it's fair. And if it is, if basically the criterion of fairness is if we have a 50-50 vote, it comes out to 50-50 districts. That's what it does. And so we know it's fair. And if it doesn't meet that criterion, you go back and fix it till it's fair. And if it does meet it, then we're good. That's the heart of what my bill does and how it's different from Delegate Price's bill. In terms of prison gerrymandering, I'll just throw that in there. It's actually a different bill, HB 319. A lot of it is similar to Delegate Price's bill. The one difference is with out-of-state people. I count people out of state. If you're from out of state and you're incarcerated in a Virginia jail, I don't think you should be counted in the place where you're incarcerated and can't vote. I think you should be counted as out of state since that's your residence, that's where you're from. That's the heart of my difference on prison gerrymandering.
All right, so you spoke a little bit to House Bill 319 too, and we may end up taking that up as part of this block too. Delegate Price, do you have a bill on prison gerrymandering, since we're sort of, I think we're covering these issues all at one time?
Yes, I had a separate bill, 1254, that was on prison gerrymandering, but I feel that I have improved it and actually included it in the sub for the criteria so that they were not separate. They were as, included in the same bill.
So if your bill were to move forward, the one that's before us now, you'd move to strike your existing prison gerrymandering bill, is that right?
I would.
But you don't want to do it yet because we don't know what's going to happen with your bill.
Exactly.
Understood. All right. Are there any members of the public who wish to speak in favor of either of these or both, or tell me which one they like better? If you guys would line up, and here's what I'm going to do, because we have this deadline, I'm going to limit everybody, you got to get your comments in about a minute, okay? So if we can set the timer for 1 minute, and I'm just looking at the number of people that are lining up and the amount of time that we have. So go ahead.
Good day. My name is Paul Friedman from Alexandria, Virginia. I drove down this morning to be here because I believe so strongly in Delegate Mark Levine's bill. Of course, I would accept, as he would, Delegate Price's approach if necessary, but I do believe that using the thoroughly analyzed version that Delegate Levine has developed, the mathematical approach, as well as the other considerations he's put into proportionality, make a great deal of sense. Our commitment in Alexandria, and I can speak, I think, broadly on this, is for an anti-gerrymandering solution. We do not believe that the legislators should choose their own voters. We believe that this approach is most effective, and at getting at that goal, much more effective than the proposed constitutional amendment. which we feel is inadequate to that. It was a poor substitute at the end of the last session. So we very much urge that this committee adopt Delegate Levine's approach. Thank you very much.
And just real quickly, so there are going to be other opportunities to speak on some of the other bills. Right now, I want, if you can use your minute most effectively, you'll just talk about the criteria bills.
My name is Annette Lang. I live in Patrick Hope's district in Arlington, Virginia. I am an activist with various grassroots groups in Northern Virginia, including Virginia Democracy Forward, which I know some of you are very familiar with. I am a passionate supporter of fair and independent redistricting. Having canvassed in many locations in Virginia, I've seen how much fair districts matter. For example, last fall, I was canvassing for you, Delegate Askew, in the neighborhood where your mom lives, a neighborhood that had been racially gerrymandered for a decade. Because of the new maps, I was able to tell folks that their vote would finally count. It was empowering to them and to me. What I want and what the people of Virginia want is an end to gerrymandering. Delegate Levine has the best bill to do that. Delegate Price has an excellent bill as well. The constitutional amendment will not do that. It is irredeemably flawed. I understand that some of you may be worried about being called a hypocrite if you support a different approach to ending gerrymandering than what passed last year, but you should be more concerned about passing a constitutional amendment that could have grave unintended consequences, and if you vote for a better alternative, you won't be called a hypocrite. Thank you.
Thank you. And again, right now we're talking specifically about these criteria bills. So go ahead.
Hi, I'm Boyd Walker. I'm from Alexandria. I'm from Mark Levine's district. Drove down here 2 hours today. Last year, the Republicans spent $6 million to defend racial gerrymandering. And I would like to help put an end to gerrymandering and have nonpartisan redistricting. One of the problems with the constitutional amendment is actually partisan, and it could be sent to the Supreme Court, and the Supreme Court then will be deciding our districts, which I think would be unfortunate. So all these criteria bills, Price and Levine's, I would like to see move forward. I just got back from Iowa, knocking on doors, and if anybody, is thinking about restoring trust and democracy, just look at what happened in Iowa, that we couldn't get the results right away, that we thought we would get by 9 p.m., and the problems that they had there in Iowa. And when we're going door to door, how much apathy there still is, that people don't think their vote counts, that they want their vote to count. We have to convince people to get out there and vote. Restoring faith in democracy is how we need to do that, by ending gerrymandering. Thanks.
Good morning, Mr. Chair, members of the subcommittee. My name is Tram Nguyen with New Virginia Majority. We work with community folks who are among the most underrepresented among us, folks who've been on the sidelines, who haven't been encouraged to be civically engaged. And we certainly prefer Delegate Price's 1255, which centers communities of color, language and racial minorities, and communities of interest in it. I think I've long said that the how districts are drawn is more important than the who, and the criteria bill that Delegate Price put forward puts very clear guardrails and guidelines around what these districts ought to look like. Not to, Delegate Levine's bill, one concern I have with it is the computer model. It takes into account the results of the partisan elections and centers that, right? And so it's 50-50 based on the outcomes of Republican versus Democrats, and just less emphasis on the actual people and communities of interest that we certainly work with. Thank you.
Thank you.
Mr. Chair, members of the committee, my name is Gary Broderick. I'm the legislative coordinator for Rise for Youth. We are an organization that fights for juvenile justice reform. And we are here to support the end of prison gerrymandering, in particular to support HB 319. One of the largest challenges we face in aligning Virginia's juvenile justice policies with what is best for all youth is overcoming the ideologies of hypercriminalization of black youth that have existed since the mid-90s. And so we've spent the last year as an organization advocating against building a youth correctional center that would house mainly black youth in a rural white area. That is the result of a set of habits and political and economic incentives that mutually reinforce each other, where bodies that are stripped of their political power are then appropriated for the political power of others. So we believe that the juvenile justice system is unfair in particular because of how political power has been organized, and that we should end prison gerrymandering. Thank you.
Thank you. Is there any...
Sorry about that. Philip Thompson, again, I'm with the National Black Nonpartisan Redistricting Organization. We're here to speak speak specifically on prison gerrymandering, that we support any bill that will allow people to be counted where they've been formerly incarcerated, where they were brought in from formerly incarcerated. We support Delegate Levine's HB 319. It's also consistent with what we're seeing. I'm a former NAACP president, and it's consistent with the NAACP's litigation in Massachusetts where they're trying to end prison gerrymandering. So we're totally in support of this bill, and I believe it's consistent with NAACP policy. Thank you.
Thank you. So anyone in the audience wishing to speak against either one or both of these bills or doesn't think we should have criteria? All right, seeing none. All right, Delegate Orrock is on my list.
Yeah, thank you, Mr. Chairman. Delegate Levine had a question about your bill, specifically on page 3.
Yes.
While I have concerns with the whole concept of basing it on a hypothetical election, would not the effect of this language mean that we would be engaged in redistricting potentially every legislative session, in so much as there's going to be a congressional election every other year, which could, under the criteria you established under this policy, if the political balance shifted, then in those districts where that balance shifted, there would need to be a concurrent change of those districts within that area, not statewide necessarily. But when a congressional district flips from red to blue or whatever, wouldn't we then have to, by this language, have to change the House of Delegates seats accordingly?
No, sir. What this says is there'll be a decennial redistricting every 10 years, and then what you do is you look back for the last 3 lieutenant governor and attorney general races, and then it uses that data to see what's a fair election. So it doesn't change the fact that it's decennial, it's every 10 years. It is true that congressional districts would also be drawn based on the past 3 elections for lieutenant governor, attorney general. And I want to be clear, these results are shifted mathematically so as to create a tie, and that's done purposely because one party wins an election or another. So, for example, the 2013 Virginia Attorney General election was very close. That would do the precincts pretty much as that was. It's averaged with other elections where Republicans won and Democrats won, and then it shifted down so we get the general partisan value of each precinct. And then what the model does is it says where there's a 50-50 election, it lends itself to a 50-50 vote statewide. And then if one party wins that election, it makes it more favorable to that party. And if the other party wins the election, it makes that party likely to get a majority. But it doesn't change the decennial elections.
Thank you, Delegate Levine. Delegate Cole.
Thank you. Just a question for Delegate Levine.
Yes.
It appears to me, you know, I'll be honest with you, I'm confused by your hypothetical election language, but I think the intent of your bill is to try to create as many competitive districts as possible.
Not exactly. If you had 100 competitive districts, one party would win 51% and they would win 100 districts. No, the goal of my bill is to say that if 2 million Virginians vote for Democrats and 2 million Virginians vote for Republicans, you get a 50-50 House of Delegates statewide, a 20-20 Senate. So if we get a tie equals a tie is the easiest way to explain this. Tie vote equals tie districts. What we don't want, what I think is unfair, is if the parties split 50-50, get an equal number of votes statewide, and one party gets 55 seats. That's not fair. The goal is if the Democrats win the most votes statewide, they get the most seats statewide. If the Republicans win the most votes statewide, they get the most seats statewide. That's what the model does.
All right, Delegate Reed.
Mr. Chairman, speaking to the bills.
Delegate Reed.
Yes, thank you, Mr. Chairman. First of all, I'd just like to commend both Delegate Levine and Delegate Price. I mean, because this is something that is really very important and very complex, and I know that you've both put a whole lot of time into that and into this, and so for that, I'm very much appreciative. I want to kind of borrow from some comments from Delegate Price where she said that this is something that has been of concern to her since high school. I've been concerned about it for a long time, but not since high school, and because that's a little bit further back for me. But I really do think that this is the time and the opportunity for us to be able to address this, because I think the hyper-partisan gerrymandering that has occurred in the past has really started to adversely affect our democracy. And so again, I really give you a lot of credit for taking the time to do this, because it's really difficult to put this type of complex information together. So thank you.
All right, so I see that we've got no more members in the queue, which means that it is time for a motion.
Before we do that, may I briefly speak to HB 319?
No, sorry.
Okay.
I've got a motion. I'd like to move to incorporate HB 1054 into HB 1255.
Second.
So it's moved and properly seconded that we incorporate House Bill 1054 into House Bill 1255. Delegate Price, you're a member of the committee, so.
I'm voting.
All right. As many as favor, it's a voice vote. As many as favor that motion will say aye.
Aye.
As many as opposed, that motion carries. All right, so we now have House Bill 1255 before us. I entertain a motion to report.
Report the substitute.
Second.
It's been moved and properly seconded to report the substitute as with Levine's bill incorporated. Delegate Price, do you have a question?
There'll have to be another substitute before full committee, but for the incorporation.
Right, for the incorporation, it'll be a new substitute.
Mr. Chairman.
Delegate Auroch.
So will this incorporation mean that those provisions in Delegate Levine's bill that do not conflict with Delegate Price's would be incorporated? Because typically that's what happens when you incorporate one with the other.
Delegate Auroch, no. The new practice with incorporation means essentially that Delegate Levine becomes a co-patron of Delegate Price's bill, but that if we wanted to actually move any specific language out of Delegate Levine's and into Delegate Price's, we'd need to do a line amendment to the substitute to do that. All right. So Delegate Price's House Bill 1255 has been moved and properly seconded to report. The clerk will open the roll. And the clerk will close the roll, and the bill reports 8-0. Delegate Levine, I know that you wanted to speak to. I want to go ahead and talk about now briefly the prison gerrymandering bills.
Very briefly, I would just say that we don't know where Delegate Price's bill goes forward. I hope it succeeds, but 319 is a standalone prison gerrymandering bill, and I would like to ask us to move it forward because we don't know where this whole process will end, and obviously if there's a conflict later on, I can withdraw it. There is one important difference. It's entirely identical, the prison gerrymandering provisions, except that for out-of-state people, we don't count them in-state, and that is a distinction.
And Delegate Price, how does your bill deal with out-of-state versus in-state? Could you briefly describe that?
For out-of-state, they are counted in the locality where they are being housed. And I did just want to say that the identical Senate companion to the one that I'm carrying has passed out of their Privileges and Elections Committee with very little opposition, so it would be coming to us as well as if mine goes to them.
So is your preference, again, to rely on the language that's in your criteria bill, or do you think that you'd like to have us move one or both of these bills forward? What's your...
My intention was for the criteria together as a whole to talk about how the district should be drawn, and ending prison gerrymandering is a significant part of that. So I would like to move 1255 forward for both vehicles.
All right. So I think what I'm hearing is a motion to strike Delegate Price's House Bill 1254.
Yes.
Is that your motion? Is there a second? Second. It's moved and properly second that we strike House Bill 1254. That's a recorded vote. The clerk will open the roll. And that motion, the clerk will close the roll, and that motion carries on a vote of 7-0. Delegate Levine would like his bill HB 319 to move forward, notwithstanding, but I think we've heard there's a Senate cognate that sort of addresses the issue of not being stuck with nothing. That said, the committee operates by motion.
Make a motion to lay it on the table.
So moved to lay House Bill 319 on the table. Is there a second? Second. It's been moved and properly seconded that we lay that bill gently on the table. That's a recorded vote. The clerk will open the roll.
You gotta let me know when you leave, because Sia could have voted. It's okay. It's okay.
The clerk will close the roll, and that motion is laid on the table by a vote of 8-0. Thank you, Delegate Levine. All right, we're going to move to commission bills now, and we will take up, I think we've got Delegate Cole, Delegate Van Valkenburg. Oh, let me go ahead and start administratively. House Bill 877, if we can take that one up first from Delegate Sickles. Delegate Sickles has requested that his House Bill 877 be incorporated into Delegate Van Valkenburg's HB 758. And I would entertain a motion to do that. It's been moved and properly seconded that House Bill 877 be incorporated into House Bill 758. As many as favor that motion will say aye. Those opposed, no. The motion carries. House Bill 877 is incorporated into House Bill 758. So we've got Delegate Cole's HB 381, Delegate Van Valkenburg's HB 758, Delegate Levine's House Bill 1055, Delegate Levine's House Bill 1645, and Delegate Price's House Bill 1256. So why don't we go ahead and start with Delegate Cole, House Bill 381.
Thank you, Mr. Chairman. Mine is, I think, fairly consistent with Delegate Valkenburg's, with the exception that mine would also establish local redistricting commissions. I think if it's good for us, I think it would be good to do this locally as well, because certainly I've seen gerrymandering done at the local level as well. But that's I think the significant difference between the two bills.
Okay, so I'm going to hold off on public input. Are there any questions from members of the subcommittee for Delegate Cole?
Yes.
Delegate Reed.
Yes, Mr.
Delegate
Chair.
Reed.
So, Delegate Cole, would that create an unfunded mandate on the localities for having to create these commissions?
You could say that, but they have to go through the process of redrawing their local districts anyways. And I know some of them do get citizen inputs and set up advisory committees already, so I think it would be negligible if there is any impact.
All right. I'm going to go ahead and move on to Delegate Van Valkenburg. Is he in the room? What we're going to do again, we're going to hear these all, and then we'll take probably a couple motions to dispense with them, and we'll hear from the public shortly. If the patrons, we're running up here, I know this is important. If we could limit ourselves to maybe 3 or 4 minutes, I'm not going to put a timer on you, but just be mindful of our deadlines. Delegate Van Valkenburg.
I don't get unlimited time.
Not unlimited, no.
Okay. Before we start, Mr. Chairman, I've got 2 line amendments that would put this in the same posture as Senator Lucas's bill on the Senate, and so I would ask that we would move those amendments, and Council, I don't know if she's passed them out yet or if she's just going to read them.
All right, so Council will report the amendments.
On line 257 of the substitute, after committee, we'll insert, and no retired judge who is a parent, spouse, child, sibling, parent-in-law, child-in-law, or sibling-in-law of, or a cohabitating member of a household with, a member of the Congress of the United States, or of the General Assembly shall be included in such list. And then after line 548 of the substitute, we'll insert a new subsection G that'll read, any justice who is a parent, spouse, child, sibling, parent-in-law, child-in-law, or sibling-in-law of, or a cohabitating member of a household with, a member of the Congress of the United States, or of the General Assembly shall recuse himself from any decision made pursuant to this section, and no senior justice designated pursuant to section 15.1-302 shall be assigned to the case or matter to serve in his place.
So Delegate Van Valkenburg, are these the Chafin amendments? Is that how these should be understood?
Sure. However
Okay.
you want to think about them, Mr. Chair.
All right, I take a motion on the amendments.
So moved.
Is there a second? Second. It's been moved and properly second that we adopt the line amendments to the substitutes. Many in favor of that motion will say aye. Aye. Those opposed? That motion carries. So the amendments, the substitute as amended is now properly before us. Delegate Van Valkenburg.
Thank you, Mr. Chair. So I will resist the urge to defend the amendment since we just heard a lot of testimony against it and stick to the criteria. But this is the enabling legislation for the amendment that is not yet before us. And so I'm just going to break it down into a couple categories that I think are important to highlight in a couple spots there. And then if you have questions, you can ask about some of the other details. So I would just point out 4 pieces to this enabling legislation that I think are important in terms of redistricting. The first kind of thing I would point out is the transparency measures that are in this enabling legislation. I'm not going to point them all out, but just a couple things to point out are things like, all records being FOIA-able, the partisanship of applicants and family members for the citizen members of the committee and the process they have to go through to show who they are and what ideas they represent. The public hearings for the Supreme Court if it gets kicked there, the circuit court judges picking citizen members in public meetings, the public participation section, right? So there's a lot of transparency built into all parts of this amendment. So that's one thing I would point out about the redistricting criteria. The second thing I would pick out, and I think is incredibly important, and I think one of the reasons why this enabling legislation is really solid and really important and fits with the spirit of the amendment, is the filtration process that you go through at each step for the members and how you get to the final product. And so, at each step of the way, it requires racial, ethnic, gender, and geographical diversity. Okay, so for each filtration step that I'm about to point out, that is included as a shall. You have to do this, right? So, but what I mean by filtration is when you get to the circuit court judges who help pick the citizen commission members, they are picked by the Chief Justice. There's a pool of people who are picked by the Chief Justice of the Supreme Court. The General Assembly then picks from that pool, right? The Chief Justice must pick based on those categories I just listed. And then the General Assembly, when they pick the circuit court judges, must also pick based on those criteria, right? And then the fifth judge, right, which would be the one that would break ties, would be picked by those four, right? So there's a filtration process for how we get to the circuit court judges we get to. Then when you get to the citizen members, you have the similar process. There's an application process that includes that partisan data that I talked about before, right? Each member of General Assembly leadership picks up to 16 nominees. Okay, once again, must follow the racial, ethnic, gender, geographical diversity component, right? The committee of judges pick from those lists and do so to the transparency piece in public. The third thing I would point out, and I'm really going to skimp on this for reasons I'll state in a minute, is the criteria. The criteria that you're going to see in this enabling legislation looks exactly like House Bill 1255. That is not a coincidence. We have worked hard on that together. And with some others to find criteria that we think do the best job of creating fair districts. And so, I would just point to my colleague, Delegate Price's comments about that, and I'll move on in the name of time. The fourth thing I would point out is the kind of multiple bites at the apple. So the commission draws these lines, they send them to us. If we do not like those lines, we send them back, right? They draw again, we get another shot before it goes to the Supreme Court. And the last thing I'll note, and then I'll stop in the name of time, is the Supreme Court component. I know there is a lot of anxiety about the Supreme Court and the partisanship of the court and all of that, and about the Supreme Court having a role. And so if you look at page 20, so if you go to page 20, it has the criteria for the court, the guardrails, if you will, for where we pick out, we say the process that they have to go through, the transparency measures that they have to go through. And I would go to page 21. Sorry. If you look at page 21, I think the most important part to pick out here is how they have to go through the process of drawing the lines. And part F, it lays out that if it does get kicked to the Supreme Court has to pick two special masters, one from a list generated by the majority party, one from a list generated by the minority party. It has to fit, the lists and who they choose have to fit certain criteria, so we can't just pick Joe Blow off the street, right, to draw maps. They have to have experience, they have to have all these things. And so essentially, if the commission deadlocked, right, they'd be throwing it to a second mini commission of two special masters who would draw that line. And I'll end there because otherwise I'll keep talking about this all day.
Okay.
I know way too much about this legislation.
Are there questions from members of the committee for Delegate Van Valkenburg? Delegate Reed.
Yes, thank you, Mr. Chairman. And Delegate von Valkenburg, again, a lot of hard work and a lot of detail in this, and I really commend you on this. I'd like to ask a couple questions on page 20. Section B, let's see here. The part that it says down here that, let's see, the court shall not later than, I know, the question that I wanted to ask was, as we look at this happening now, how are we going to be able to implement this timeline, as a lot of these things were kind of written into this, that they would need to happen in June or July, and now by the time that this becomes law, we'll be well past that. Is there a way that we're going to be able to implement this on a compressed schedule to be able to satisfy redistricting for 2021?
And Mr. Chair, Delegate Reed, I think I would respond that this is just a problem that Virginia faces every 10 years because of the nature of our elections, and this schedule is as probably about as compressed as it can be. And one of the concerns that we've addressed is to try to push up the public meeting process to get public input by doing it through the Privileges and Elections Committees to try to fast track to the best that we can this process. But I mean, some of this is just baked into the calendar. And so, we're going to have later primaries. That's just going to have to happen. One thing I'll note about that, by the way, is that originally, as the language was written, the Supreme Court would have had control over that process, right? And the revised version, the General Assembly has control over that process. But, I mean, I don't think there's a satisfactory answer to that. I think it's just the nature of Virginia elections. Yay, every year.
Another question?
One more, Delegate Reed.
In the last sentence there of Section B, it says, in enacting such rules and procedures, the court shall give consideration to the provisions of this section. I know, and as you stated, there's been a lot of concern about the role of the Supreme Court.
Sure.
And I'm just curious, because I read this part where it says the court shall give consideration to being somewhat optional, somewhat open-ended, and I think I would look for something more prescriptive that says the court shall follow the provisions of this section as opposed to give consideration.
Hold on, let me find the appropriate part. Mr. Chair, Delegate Reed, I mean, I think I would say to that, if you want to strike the word consideration, it's not going to give me heartburn. But I would go to if you actually go to the Constitution, which I'm going to pull up right now, and you go to Article 6, and you go to Sections 4 or 5, and you can go to 1 or 8 as well. I mean, it's pretty clear that the General Assembly can create rules and procedures for the Supreme Court. And so I take your point, but I think at the end of the day, we are allowed to do this. And so if you want to strike the word consider and just say shall follow, I'm not going to have heartburn over that, but I think that we're in a good place.
I agree, but I wanted to raise it as a possible concern, and I'll work with the patron. One last question, Mr. Chair.
One last final question.
Again, and this is about being more prescriptive in Section C, public participation in the court's redistricting deliberations shall be permitted. And then such public participation may be through briefings. Again, do we need to be more prescriptive and say shall be? Because I know the public really wants to be involved in this.
Delegate Van Valkenburg.
Thank you, Mr. Chair. Delegate Reed. I will say to you that I have talked to council about that section. I brought that point up before. And I once again, I would go back to if we're on a compressed schedule, so we need to be careful about we got to be careful about what we are saying there, because we are going to, if it gets to this point, we are going to be on a fast timeline. And the second thing I would say to that is there are typical court procedures that are used when you're before the court that allow that process as a part of normal procedure, right? So you're going before the Supreme Court of Virginia, there are legal briefs, there are amicus briefs, there's public hearing. You have all those steps, and so the Supreme Court's not going to, in the dead of night, be able to do this because they are going to follow the court procedures that they follow. And so I think just built into the procedures of the court and built into the procedures of our legal system, this is covered. And so I would say that I think that is addressed. Yeah.
All right. Delegate Price, House Bill 1256. Delegate Van Valkenburg, we're not taking a vote yet, but we will come back to you, so don't go away.
I wasn't going anywhere.
All right. So we're fast approaching our soft deadline. I probably shouldn't have announced it that way, but let's go.
Yeah. So, Mr. Chairman and committee, looking at the substitute, I want to say that there were some assumptions in creating this legislation and in working with Skylar when we were Delegate Van Valkenburg when we were talking about criteria. I do assume that we all want a process that's fair and transparent, but there are some issues with the proposed constitutional amendment, and I have been consistently against. It is not new, and my concerns from 2019 have not been assuaged with the new composition of the General Assembly, because my concerns are not about party, but about people. For 400 years of voter suppression, including a bill that I have this year to remove acts of assembly that were race-based disenfranchisement as soon as 1950, when some of our members of this general body were alive, poll taxes didn't really end until our previous governor acknowledged that having to pay fees before they got their civil rights restored was a form of poll taxation. And for the Bethune-Hill case to strike down districts that were drawn in 2011 due to their being unconstitutionally racially gerrymandered, we can see that this suppression still has its grips on our democracy, but it doesn't have to moving forward. Communities of color still need the protections of the Voting Rights Act due to the existence, persistence, and radiating ramifications of structural racism. And it is my contention that due to that, these protections have to be included in anything that we add about redistricting to our Constitution and nothing less. We have seen with the gutting of the VRA that we cannot simply refer to the document, so we have the actual language of Section 2 and Section 5 pertaining to redistricting, as I said, in the actual criteria. And opponents of my bill have said that it doesn't fix the issue just because legislation can be changed, in answer to some of the Black Caucus members' objections. And we were told that legislation would be sufficient to fix our concerns for communities of color, and I say you can't have it both ways. I would like to point out that the product of the conference report that got us here to the insufficient amendment was the product of a 7-member group, 6 white men and 1 white woman, and 0 people of color, and it just reiterates that we have to mandate that a commission drawing lines that would affect the entire Commonwealth be reflective of the demographic makeup. And so I completely agree with the Delegate Reed's suggestion, and so that's why in House Bill 1265 you see it does not say shall give consideration to racial, ethnic, geographic, or gender diversity. It says shall ensure. And that is what I think the members that raised the concerns were looking for. And I want to speak now to trust. Proponents of the proposed amendment are dependent upon the trust that enabling legislation will stand beside the amendment in perpetuity. That is the idea of legislation beside an amendment. So why not have that same trust that we could pass a better amendment in 2021 and vote again on it in 2022 to get to a better Constitution by way of this amendment? Delegate Reed raised another point, the timeline. You will receive a handout that shows you the timelines prescribed in House Joint Resolution 71, the proposed amendment, and House Bill 1256. And you will see which one is a little more compressed. And so, because a determining factor of the schedule for House Joint Resolution 71 is dependent upon when we get census data, I've given you 4 different scenarios. If we were to get census data, first of all, the amendment says that basically by January 15th, the committee has a public meeting to select the commissioners. If we were to get the census data on January 16th, the clock starts. So where are the public hearings that we've been hearing about? Because you can't really get to a lot of that. And so we added the enactment clause that the P&E committees would do that. That's more legislator involvement. And so when you look at the other timeline, if we were to get the census data on February 1st, and they didn't need extra time, we get to potentially getting to the Supreme Court in April. If they were to get the census data February 1st and they did need more time, we're ending up at the end of March before the commission would then kick that potentially to the Supreme Court. If we were to get the census data in March, which I have heard is a very real possibility because of the late start that the Census Bureau got because of the government shutdown and all of the dysfunction up the road, then we would be looking at a vote on a second plan if needed in June 3rd. I will remind the committee that early voting starts on September 18th. And a short primary season would be incumbent protection. And I know none of us wants to cut into early voting protections or allowing for our UOCAVA voters to have their ability to have their say. So the handout describes what could happen when it's based on receiving that, and it also describes what the timeline is in 1256. We have spent all session saying that we want to make it easier to vote, and I think that it would just be reprehensible to cut into the primary season or the ability for people to early vote. The issues with the amendment led us to needing a different alternative, and that's what I'm presenting here before you. With the substitute, it started with the totally independent commission. I got the feedback that wouldn't pass the House or the Senate, so I changed it. And you'll see a lot of similar language from the constitutional amendment for the committee and commission process as prescribed in the amendment. And so what I think we have here before us is a looser timeline to allow for mandated public input. It no longer has the emergency clause with the substitute. The timeline itself disincentivizes punting it to the end. It adds an additional layer of transparency by demanding that there be transcripts and that all of the meetings be video recorded, and then that be added to it. And I'm skipping over stuff, that's fine, but I really want to really think about what it is that we're doing. The momentous act of adding something to the Virginia Constitution that is supposed to cover all of its citizens, and I believe that together with House Bill 1255 and House Bill 1256, it would establish rules to govern the 2021 redistricting process so that we could come back together, have an amendment that equally covers all of the residents and citizens in Virginia and get that passed next year so that we can have clear, explicit protections for suppressed communities of color.
Thank you, Delegate Price. Are there any questions from members of the subcommittee for Delegate Price at this time? All right. Delegate Levine, you have two?
I do, but I will be briefer than both of them on both my bills.
Okay, go.
Okay. First of all, I want to associate myself with virtually everything Delegate Price said. I also fear the constitutional amendment. An amendment trumps a law, and that's true of the Constitution, and the constitutional amendment says shall establish with no criteria whatsoever, and I fear that the Supreme Court will do what the Constitution tells them to do. But even if they don't, even if they follow legislation, the answer is if they're going to follow legislation, let's just use legislation. And then do a constitutional amendment in the future, which I've also proposed, to enshrine independent redistricting in our Constitution. When it comes to legislation, I have two proposals, HB 1055 and HB 1645. 1055, if it looks familiar, it's exactly the language, word for word, of the constitutional amendment with only one difference. It's a bill, it's not a constitutional amendment, so if the committee fails, if the committee succeeds, it goes to the legislature without amendment. They can vote up or down. If that doesn't work, they try a second time, just like the constitutional amendment. It goes to the legislator up or down. If it fails a third time, then the legislature can draw the maps. That's the only difference. Other than that, it's identical. If people think the commission is going to work, then it will work, whether on the constitutional amendment or HB 1055. HB 1645 is identical, word for word, to SJ 274. This is the bill drafted by One Virginia 2021, presented by Senator Hanger last year. It is their preferred solution. They made clear that this is what they prefer. It is a different way of doing an independent, nonpartisan commission. The only difference, actually it's identical except that it's a bill. It's not an amendment. So I understand that we can't do an amendment this year that incorporates these things. So these are bills that would do exactly the same thing. And I would also support a constitutional amendment. Before we change our Constitution, we should get it right. This will protect us for 2021, and a constitutional amendment will protect us for 2031 in the future.
I think I understand the concept of what you're trying to do. I think it's pretty clear. So if I can go ahead and see if there's any members of the public wishing to speak in favor of any or all and against, and I guess you might be able to mix it up. Tell us what you're for, which you're against, and if we can go ahead and set the timers at 1 minute again. I apologize that we have to be so brief, but we've got a real hard deadline looming. Delegate, go ahead.
Once again, Paul Friedman from Alexandria. I'm pleased to be here to support my delegate, Delegate Mark Levine's approach to this, his bills. It's, I think primarily, I'm a member of the Alexandria Democratic Committee, as is my friend Boyd Walker, who's came with me today. And we feel strongly about the idea of this a fair approach to gerrymandering and to a better approach than what we've had in the past, even though we're partisan Democrats, clearly. But the biggest concern we have, I think, is putting something into our Constitution that's never been tested and that has a potential for really robbing the party that wins in this state from the appropriate level of representation that the people have fought for. We think it's critical that we have fair representation, and I believe that the proposals that Mark has offered would achieve that. We also want to speak in favor of the deep concerns that have been raised by Delegate Price. We think that her approach is also commendable. Thank you very much.
Thank you, Mr. Friedman.
Thank you so much. Annette Lang again. As much as I do support and did support Delegate Falkenberg, excuse me, I do think this constitutional amendment and with the enabling legislation is deeply flawed. I think when the delegate was speaking, he mentioned the words General Assembly a number of times. That is a partisan body. That should not play a role in redistricting. Both Delegate Price's and Delegate Levine's eliminate that. So I would urge you to think in those terms. I would also add that the fact that as Delegate Price said, the fact that the constitutional amendment contains no criteria is in and of itself, in my opinion, reason enough not to support the enabling legislation. And both of these wonderful delegates have given you fine alternatives. Thank you.
I'm Greg Lusick. I'm a member of the board of One Virginia 2021. I'm a former chief staff attorney in Supreme Court and a senior assistant attorney general. I worked for 30 years for the courts in the attorney general's office in the Commonwealth. And we're here to speak in favor of House Bill 758. It is the enabling legislation that will implement the constitutional amendment, and it's a compromise bill. It takes into account and incorporates all the best sections of Delegate Sickles' bill, Delegate Cole's bill, Delegate Price's bill. Delegate Van Valkenburg's bill is the complete package. It ensures a diverse commission in every phase of the process. It requires the selection people to use the racial, ethnic, geographic, and gender diversity of the Commonwealth. It supplements many of the details that could not be included in the abbreviated constitutional amendment, including the timelines. It does not relax the timelines, as Delegate Price says her bill does. It sets forth specific detailed application procedures, and it is, keep in mind, its enactment is contingent upon the passage of the amendment. It's conditional, so that you can pass it today, but if the amendment doesn't pass, then it will not take effect. So at least
Understood.
Keep the train moving.
We understand that consideration. Thank you.
Thank you.
Again, Tram Nguyen with New Virginia Majority. We care deeply about redistricting reform, and I have said that the how is more important than the who, but I also believe that the who is important. And taking a commission approach, I think, is the way to go, right? To take the redistricting process out of the hands of legislators instills confidence in voters that the maps are fair. We appreciate HB1256 slow approach to make sure that the commission that is set up we have some time, and it includes a lot of public transparency and public input, which is really important. For the last several months, especially after Bethune-Hill, we've been going into communities and having them draw their own maps just to sort of see how they would define their communities of interest. And it's been very surprising to me to see how they define their communities. Assumptions that we make from just looking at data and looking at lines and boundaries is not what people who live in those communities actually want. And so whatever commission or whatever process that comes forward, we really need to be thoughtful about that public transparency and input. Thank you.
Thank you.
Philip Thompson with the National Black Nonpartisan Redistricting Organization. We support House Bill 758. We support the constitutional amendment moving forward. We think that redistricting should be taken out of the hands of the legislature. We think this is the best way. We think the constitutional amendment is extremely important, that it's in the Virginia Constitution so that it cannot be changed after one party loses control of the General Assembly. So we believe this bill will help implement that, coming with the legislation coming out of the Senate. So we support HB 758. Thank you.
Yes, ma'am.
Good morning, Mr. Chairman, delegates. Carol Nagle with the League of Women Voters. And we support HB 758. We're very keen on the transparency and the diversity. And we are definitely committed to the concerns Delegate Price has to make sure that there is diversity.
Thank you. All right, is there anyone here wishing to speak in favor of traditional political gerrymandering? All right, so seeing none, I'm going to go ahead and, so I think administratively we got to do we could do a little bit of winnowing. I think we've got a couple of choices. Hold on, Delegate Price.
Mr. Chairman and committee, I just wanted to say if mine is chosen to go forward, that I am completely in agreement with the amendments, the line amendments that Delegate Van Valkenburg made to his, and the appropriate place in 1256 would be between lines 287 and 302.
Let's wait. We're going to get there in just a second, because I think what we want to do is I want to narrow this down a little bit. We've got two amendments that are what I would call enabling legislation that are contingent on the amendment passing. Something just for the audience, for everybody to tell you where we are. So what's not on the docket today, and what won't be considered today, is the second reference resolution itself. And the reason we're not considering the second reference resolution is because we don't have to yet, because we adopted a procedural resolution at the beginning of the year that puts off the deadline for second reference constitutional amendments till later in the session, because some of us wanted to make sure we had an opportunity to see how any enabling legislation or alternative legislation might develop and get us to a later point in the process before we had to make a decision on whether we wanted to support the constitutional amendment or not. So what's not before us is the constitutional amendment. That doesn't mean that it's not going to pass or that it won't be brought up later or that it can't be, nor does it mean that it will. It just means we don't have a deadline to act on that today. So I think what we need to do is we need to pick from one from column A and one from column B. And so column A, we have Delegate Cole's bill and Delegate Van Valkenburg's bill, which are enabling legislation, and we can advance one of those or none of those, but I don't think we ought to advance both. So let's start with House Bill 314, Delegate Cole's bill. Is there a motion on that bill? Or 381, excuse me. Delegate Cole's 381. Is there a motion?
I move to lay it on the table.
Second.
It's been moved and seconded to lay House Bill 381 on the table. As many as favor that will indicate their preference on the recorded of the.
Can you withdraw your? Can
The clerk will destroy the roll at the request of the big chairman.
Can you withdraw your motion from?
Yeah, I will throw my motion.
All right, is there a motion? All right, that bill is dies for lack of a motion, or it's left in the committee. Is there a motion on House Bill 758?
Mr. Chairman?
Yeah, Delegate Reed.
I would like to, just to be sure, to put it in kind of the same tone, especially after the very compelling remarks from Delegate Price. I would like to make a motion to amend part of line 523 on page 20 to strike "give consideration to" and replace that with the word "follow."
So, clerk, do you get that amendment? Is that a friendly amendment, Delegate Van Valkenburg? All right, so it's moved and properly seconded to make the line amendment. So can you say it one more time, Delegate Reed?
Yes. So now the last sentence will read, "In enacting such rules and procedures, the court shall follow the provisions of this section."
All right, as many as favor of that motion will say aye. Aye. All those opposed? All right, that line amendment is adopted. So is there a motion on the substitute as amended?
Make a motion to report.
Second.
It's been moved and seconded to report House Bill 758 as amended with the comment that we heard from the audience that this bill has a enactment clause on it that says it would only become effective if the constitutional amendment were to pass. The constitutional amendment can't pass a ballot measure if it's not reported from the General Assembly. Delegate Price? You're a member of the committee, so Delegate Price, would you like to speak to that motion?
Yes, Mr. Chairman, I wanted to speak to that motion. The governor has provided funding, and there are several provisions in both of our bills that would have a financial impact, especially on DLS and some of the things they need to do. So I think the appropriate motion would be to report and refer.
So Delegate Price, we've not yet gotten a letter to that effect. However, this is a recommendation from the subcommittee to the full, and assuming we do get such a letter prior to full, then the final motion would probably be to report and refer, but I don't like to make those assumptions until I get a letter, all right? So I think the motion we have before us is to report House Bill 758 with a substitute as amended, understanding that this has got an enactment clause which requires the amendment to succeed before it would become law. Speaking briefly to that motion as myself, I want people to understand that a vote for this doesn't necessarily indicate a member's preference for this approach, but more that if we are going to have this amendment pass, some of us want to make sure that we do have really good guardrails. And I particularly like the two special commissioner provisions and a lot of the guardrails that are there. And so don't necessarily take this vote that you may see in favor of the criteria as a favor and support of the amendment. It's if the amendment passes, this is how we'd like it to work vote. So with that, the clerk will open the roll. The clerk will close the roll. And the motion reports by a vote of 8-0. All right, now we've got from bucket B, right, these are going to be legislative redistricting commissions, which could pass with or without the amendment, and they could stand on their own. If the constitutional amendment passed, some of these would be inconsistent with the Constitution, so probably would have to go away, but this would be track B. And so from those, do I have a motion on any of those amendments?
I'd like to move to report HB 1256.
So House Bill 1256 has been moved to report. It's been properly seconded. Delegate Price, did you have amendments for all the motions before us? Do you have amendments you'd like us to take up before we act on that motion?
Yes, the amendments that were brought from the Senate for 203 and 758, I'm amenable. It would be different lines, 287 and 302, to talk to who couldn't serve on the citizen part of the commission.
Council, do you understand the amendments that are being articulated? Do you need to see those?
I understand the amendments she wants to make. I don't think that they'll go where she's saying.
Wherever council says that they should go.
That sounds good.
So this is the amendment in concept to conform to the extent possible Delegate Price's bill to the changes made in the Senate.
It would certainly be the same language, just probably in a different place.
Okay, so is everybody comfortable with that amendment in concept for full? As many as favor that amendment will say aye. Those opposed? That motion carries. And so the amended bill is now before us, and there's been a motion properly made and properly seconded to report. Barring any further, as amended, barring any further discussion, the clerk will open the roll. And that clerk will close the roll. That bill reports on a vote of 5-3. Are there any motions on the remaining legislation that's before us in this category that we just heard from? Hearing none, we're going to move on to, I think, one more bill on the docket, which we dealt with the prison criteria bills. So I think the last bill on the docket is, we got a couple, right? So now we got ballot bills. All right, so Delegate Van Valkenburg, you have a ballot bill for the constitutional amendment, which again is subject to today's deadline. So a vote in favor of the ballot bill doesn't necessarily indicate support, although a vote not to advance the ballot bill would certainly scuttle the amendment, but I don't know if that's anybody's intent at this point. So do you have anything you'd like to say about the ballot bill?
Thank you, Mr. Chair. In the name of brevity, this is what will go on the ballot. So I would hope you would act favorably.
That's House Bill 784, Delegate Van Valkenburg. There's been a motion to report, properly seconded. The clerk will open the roll. The clerk will close the roll, and that bill reports 7-0.
Thank you, Mr. Chairman.
And then we've got Delegate Lindsay's bill. Nope.
Mr. Chairman,
Delegate Lindsay.
having voted on the prevailing side by which we passed the measures 758, I'd like the matter reconsidered so that I can step out and let a member cast their ballot.
Okay, so those, Delegate Lindsay, having voted on the prevailing side by which we recommended reporting House Bill 758, moves that we reconsider that vote. As many as favor that motion will say aye. Aye. Those opposed? All right, the matter is once again before us. The clerk will open the roll. To report with a substitute. And the clerk will close the roll, and the bill is recommended for reporting by a vote of 7-0 with one abstention. All right. Delegate Lindsay, House Bill 108. 105. That one.
Mr. Chairman, House Bill 105 is a very fine measure that takes some stress off of the very challenged staff of LIS. In the present iteration of our activities, we tend to put an onus on them in terms of descriptions, in terms of boundaries and lines that just is not necessary or practical in the 21st century with computers and the way that it's now done. And for that reason, I have crafted this motion. And I'm sure that some of the wonks of the committee are going to want to get deeper into the weeds. And so I'll yield the rest of my time to committee counsel. That would be you, Mick.
Does council have anything she'd like to add for the edification of the subcommittee? Would you like to speak for or against this bill?
Definitely don't think that's appropriate for council, but DLS would be happy to see this bill pass.
All right. Are there any questions for the patron from members of the subcommittee? Delegate Cole.
Yeah, my only concern is that sometimes when we pass district boundaries, the citizens, they like to look at it and have a written description rather than just relying on census blocks, and I'm wondering if that might negatively impact the citizens being able to determine where the district boundaries are.
And that's a question for the patron?
Yeah.
No, that's a question for council.
Delegate Cole, we did pass legislation a year or so ago to require GIS maps and that they will be available on the Department of Elections website, on the Division of Legislative Services, redistricting website. We do have maps that the public can view. These are very intensive and tedious descriptions that are driving down roads and then turning left at the stop sign and then going up the mountain. So I'm not sure how useful they've been to the general public in recent years.
And I would observe that kind of tedium is prone to error when it comes time to typographical and otherwise. It can create confusion. Is there any member of the public wishing to speak in favor of this bill?
Again, Tram Wynn with New Virginia Majority. After the Bethune Hill case and the special master put out the list of precincts that were moved and shifted around, I know that I certainly was confused and several folks were confused because of split precincts and certain places being named in District 72 and then also District 73. And on election day, sometimes some voters show up and think that they are in a particular district and they get the wrong ballot because of a split precinct. It causes some confusion, and people might say that they, should be voting in this place versus the other place. As council said, with the GIS maps and the shape files that are publicly available, it's actually easier to take a look at that and see, oh, this street is where I live and I should be in this district versus the other district. And so I think this is a good step forward. Thank you.
Is there anyone in the audience wishing to speak against this bill?
Mr. Chairman, I have a motion.
Delegate Krizak.
I'd like to move to report.
It's been moved and properly seconded that House Bill 105 be reported, recommended for reporting. As many as favor of that motion will indicate on the electronic voting board. The clerk will close the roll. That bill is recommended for reporting 8-0. Delegate Lindsay, no bother coming to committee. You're good to go.
I need to come to committee.
Oh, that's right. You do need to be there. I entertain a motion to adjourn. Moved and properly saying that we adjourn. All in favor, say aye. We are adjourned.